Insurance Lawyer, the podcast where we discuss topics concerning lawsuits between insurance companies and their policyholders. I am your host, Evan Schwartz, founding partner of Schwartz, Conroy, and Hack. The firm represents business and individual insurance policyholders in claims and lawsuits against their insurance companies, helping policyholders get their claims paid. Today, we're going to be discussing personal injury claims in the COVID world. And as we all know, the coronavirus has created lots of interesting problems in our society. One which has already started to rear its head is lawsuits being brought against businesses for claims that people suffered injuries due to contracting COVID at the business location. So today we're going to get into that, and I'm pleased to have with me my partner, Matt Conroy, to discuss some of these issues. How you doing, Matt?
Doing well.
So to start off with, if you're a business and somebody has asserted a COVID-19 claim against you, they hired a lawyer and they sent a letter making a demand, or a lawsuit has been filed, unfortunately, against you as employer, there are a couple of steps that you need to start out with. The first is that you may have a policy that covers this potential claim or this potential lawsuit. Now, for those that are or have been dealing with potential insurance recovery issues in coronavirus claims, most people and most businesses have what they call an all risks policy, a policy that covers both property damage to their premises as well as liability claims that are brought against the business, right? And so those coverages are distinctly different and have distinctly different provisions. For the world of property damage or business interruption claims, we've done a lot of talking about those types of claims, and the vast majority of those policies are having those claims denied due to things like lack of direct physical loss and or a virus or communicable disease exclusion. And those two issues seem to pervade most of the policies in the United States for businesses that bought all risk policies on the property damage side. However, on the liability side, or when claims are brought against the business, there are quite a number of policies that do not have an exclusion for virus or communicable disease. I would say just a thumbnail, maybe greater than 50% of them did not have that exclusion. So assuming that you may not have coverage for this type of a third-party claim brought by an employee or a former employee or a guest of some kind that was at your premises and then claims that your business was responsible for them contracting COVID-19 and all the symptoms or problems or ongoing issues that they suffered as a result of having COVID-19 may very well be covered. In addition, a lot of the exclusions contained on the liability portion of that all risks policy may be a traditional pollution exclusion, and depending on the state that you're in, that type of traditional pollution exclusion may not be legally applicable to a virus or a communicable disease. And that's going to require probably a little bit more investigation by an attorney to see whether or not that's accurate and whether or not ultimately your insurance company would refuse to cover the claim because of a pollution exclusion like that. But that in and of itself is another interesting issue. So the first thing is, fear not, you may very well have coverage even if you made a business interruption claim and your insurance company told you on that side of things, hey, sorry, not covered. And so the advice that I give, and I would give anyway, to anyone that receives a claim for personal injury, whether it was for COVID or otherwise, is to put your relevant insurance companies on notice the claim, if the lawsuit hasn't been filed and you've gotten a letter from a lawyer or some other basis to believe a claim is being asserted against the business. You put the insurance company on notice, and you may be surprised that you have coverage. Now, be advised that as all of these policies come up for renewal, they're across the country, the insurance companies are looking to make sure these types of exclusions are now in these policies, both on the property damage side and on the liability side. And so if you did receive a letter or something of that sort and your policy hasn't yet been renewed, you want to put that company on notice as soon as possible. Most of these policies realistically are not claims made policies, so it's not when the notice is given, it's when the occurrence happened or the injury occurred. But either way, if you have belief that there may be a claim being asserted against your business related to COVID-19, you want to get that notice into the insurance company as soon as possible. and you may be fortunate enough to have it covered. Now, before we get into some of the other issues surrounding the defense of these claims, where Matt's going to sort of walk us through some of these issues, there's another issue that people need to be aware of, and that is the potential for claims brought by employees against the business for contracting the coronavirus. And what's going on out there in the universe right now is, the first traditional thing that you need to know is if an employee gets sick or injured when they're on the job, to the extent that that injury arose as a result of their employment and occurred during the course of their employment, typically in a state where there's workers' compensation benefits, you're going to have workers' comp covering the medical bills and some of the additional value of that person's loss or injuries or illnesses or residual side effects, in this case from coronavirus, by the workers' compensation insurance companies. The problem that is being seen already across the country on this is that a lot of these employees, they can't demonstrate that getting a disease like COVID-19, much like just getting the flu, had anything to do with their employment or had anything to do with something that occurred during the course of their employment. And so a lot of these workers' compensation insurers are taking a very hard line and saying, you can't prove, Mr. Employee, that you got COVID-19 because of employment-related activities. And therefore, you have the burden of proving that in order to get workers' compensation benefits, and you can't prove it, we're not paying it. And there are decisions coming out in workers' compensation judges and boards that are saying, hey, insurance companies are right. You can't prove that this arose out of your employment relationship, that it was part of your employment, that it occurred during the course of your employment, and it's not going to be covered. Now, similarly, if they can't get workers' compensation benefits, then they're also going to have trouble getting a claim to be asserted against an employer, even if they couldn't get workers' compensation benefits, because the employee is going to have to establish that the injury occurred as part of and during the course of their employment in order to have liability against the employer. So the same problem for workers' compensation benefits is going to come up when it comes to a liability claim by that employee. Now, there's different exceptions going on, and each state has its own slight vagaries. Plus, there's potential rulemaking and legislation flying around about first responders and essential workers, and also, when you're talking about healthcare workers, where the risk of contracting a disease is actually part of their job as a nurse or a doctor or some other healthcare worker, that's going to be a bit of a different story. But the vast majority of employers out there, this is going to be less of a problem for them. The final thought on this is, and this is just to use New York State as an example, New York State has an exception to the bar for workers' compensation on bringing a third-party liability or negligence claim against an employer, and that is for grave injuries. So it's possible that someone could have contracted COVID-19 as part of their responsibilities at their job, or have a good argument for it, would ordinarily be covered by comp and therefore barred. But if they got very, very gravely ill, passed away, or had some terrible residual side effects that are permanent in nature, there may be a basis to assert that claim. That's not going to be the vast majority of what we're talking about today when it comes to protecting your business from personal injury claims arising out of COVID-19, but it's just something that you should be aware of and think about if a claim comes in and it involves a very, very, very serious set of side effects or death as a result of the coronavirus. So that's sort of the, what do I do, and do I worry about, the employees' side of things? The greater side of the liability claims that are going to be coming in on COVID-19 are going to be what we call guest liability. So someone comes to your premises, they're a customer, they're a client, they're stopping there because they are a UPS delivery person, or they're coming there to try to promote and sell some of their services or their goods, or for whatever reason they're present on the business premises. If they were to contract COVID-19 and they are able to link that contraction of the disease and getting it to your place of business, then the possibility that they can make a claim against your business and say that you were liable for negligence in terms of them contracting it is going to rear its ugly head. And being prepared for that is a bit of a moving target, and certainly very interesting in light of the fact that what we know about COVID-19 continues to be a moving target. And Matt is going to talk to you about some of the issues that you need to be thinking about and some of the issues that you need to prepare your business for to protect you from those claims. Matt?
Just to briefly recap on the first part of this topic, there are things that are in your control and there are things that are not in your control. You've got whatever policies you have, and to the extent that you get a demand letter or you become aware that an employee or somebody has contracted the virus, is suggesting they contracted it at your place of business, you want to put all of your carriers on notice, whether you think it's covered or not. And that could be GL, that could also be a directors and officers policy. It could be an EPLI coverage. You don't know how these things are going to shake out, because the way that the carriers and the way that courts are going to deal with COVID-19 claims is evolving. We don't really know. We're treating it by sort of analogizing to different types of claims over different periods of time, but we've not seen this broad a pandemic. Even SARS, as devastating as that was, didn't have nearly the impact or the frequency or duration, or at least it appears it won't have the duration that COVID-19 is having. So what you can do, though, is look at matters that are in your control. And there are ways to mitigate your damage, and there are ways to limit your liability by taking certain steps. And some of these are optional and some of them are required by state, but these are basically issues of establishing and enforcing protocols in your place of business. And there are state guidelines, there are CDC guidelines, there's WHO guidelines, there's OSHA guidelines, and there are EPA guidelines. That's 5 different administrative bodies that speak to these things. And for today's purposes, I'm going to refer to New York, but wherever you're located, it's incredibly important to look at the state guidelines for your particular type of business and the date and phase that you're in, because the requirements and the recommendations change depending on whether you're in phase 2, phase 3, or phase 4. Some of this is really going to sound like common sense, but from a trial lawyer's perspective, what I'm talking about is when the claim comes, whether it's insured, uninsured, doesn't make any difference to me. But my question is, how do I prepare my defense? How do I present my defense? What does the evidence consist of? And to the extent that you are creating written protocols that are either in compliance with or stricter than the state guidelines, the federal guidelines, and then the various agency guidelines, OSHA and the EPA, that's going to give me a baseline to say, we did everything that we possibly could to inhibit the spread of virus at our workplace. And ultimately, the question of negligence, the questions of whether or not you deviated from the ordinary standard of care as an employer, as a business owner, as a tenant, as a landlord, as a boss, are going to be based on what steps you took and when you took them in response to this virus. So New York, for example, in the end of May, they issued guidance for office-based return to work policies. And it's an interesting read. Anybody who owns and operates a business in New York really must look at this, because there are mandates from the state, and they aren't simply mandates about posting recommendations of social distancing or wearing masks or washing your hands, but there are actually mandates about keeping records and logs, producing written protocols that you distribute to your employees and have them sign off on. And so the standards basically incorporate 3 or 4 different components, one of which is physical distancing of people and of workspaces. And reading through these, they use the word shall and must and should seemingly interchangeably at times. Clearly, anytime you see a must or shall, you should take that as a mandate. And to the extent that it's in the recommendation and not in your policy, you are creating potential liability for yourself, because all the employee has to do, or the guest or the FedEx man, once they can establish proximate cause that they contracted the virus at your place of business, if they can link that to your failure to include this as a protocol, or that you included it in the protocol but failed to enforce it, they're well on their road to establishing a deviation from the ordinary standard of care. But physical distancing, spacing employees, abiding by workforce restrictions. I see offices opening even in our building where seemingly everybody's back to work. We're still in phase 2. We're supposed to be at a 50% capacity. So to the extent that you're exceeding capacity, you're making it easy for a potential plaintiff to make a case for a deviation from the standard of care. There are some things where there are recommendations but not mandates. And these are things like bidirectional foot traffic. Depending on your office layout and your space, those are things that you would think about. Gatherings in enclosed spaces. The recommendations are things that, even though they're not mandatory, that's probably something that you want to have in your written policies. Even if there are variations in compliance, you are at least demonstrating that you've considered them, that you've tried to implement them, and that you've taken reasonable steps to protect your property, your guests, and your employees.
So Matt, are you saying that for businesses, they should have a written policy?
Yes, absolutely. They must have a written policy. The employees must acknowledge receipt. And then on a daily basis, a log must be maintained where the employees are coming in and sign a declaration separately every day. But when they come in, they have to sign an acknowledgement that essentially affirms 3 things. 1, that they have not knowingly been in close proximity or contact 14 days with anyone who's tested positive, that they have not tested positive themselves within 14 days, and that they haven't experienced symptoms of COVID-19. The symptoms are listed in the CDC guidance, but they are essentially cough, shortness of breath, difficulty breathing, fever, chills, muscle pain, sore throat, and new loss of taste or smell. So the easiest way to do that is simply to create a sign-in sheet for people to come in, and at the top, it's going to read, today is X date, and employee A, B, and C acknowledge those 3 things and that they don't have those 7 symptoms. That is part of the screening and testing process. That the language in the New York State Department of Health recommendation says the responsible parties must implement mandatory daily health screening practices of their employees and, where practicable, visitors. But screening is not mandated for delivery personnel. That means that clients, salespeople, people that you invite onto your property or into your business, they have to sign that log as well. I think the ability for a potential plaintiff to establish a causative link based on the failure to maintain the log is probably a stretch, but the fact that you create it and maintain it certainly would help to buttress your defense that you have taken all reasonable steps to protect them. So again, create a written plan, follow what's written in the Department of Health guidelines. It's 25 pages long. It's not, it's not overly technical or scientific. It's pretty much common sense. And create your document, distribute it, have everybody sign off on it, and get yourself going. But maintaining that and being vigilant about potential exposure is incredibly important. And obviously, everybody's interested in keeping their guests, their clients, their employees as safe as possible. And every employee is a potential danger to every other employee. And as antithetical as that seems, you have to protect your employees from one another. There's no obligation to conduct temperature screenings, but I have seen protocols from industrial hygienists where they recommend in high density areas and in areas where there's been high incidence of contraction of the virus to require a scan thermometer of every guest who comes into the property. I don't believe that's necessary, but it certainly is something that you could do if you were in a small enough office or you don't have regular traffic. You could potentially do that. If you're in a high traffic area where you have people coming in all day long, that would probably be a little bit much to ask. But those are the factual issues that ultimately will determine whether or not your negligence claim is defensible.
Question, Matt. So what about the fact that you've got, multiple guidance points from different governments, right? You have the federal government's points with the National Institutes of Health, the CDC, you've got the state and city guidelines. What happens if you're looking at them and you see that there appears to be an inconsistency in them or a contradiction in them? What do you as a business do? How do you follow? Who's the primary here?
Well, the state is the primary. You're under the state's jurisdiction. They have mandatory policies for you to reopen and comply with the executive orders. So you start with the state. To the extent that there are recommendations or guidelines from the CDC or the NIH or OSHA or the EPA that are more restrictive, you certainly could and maybe even should consider implementing those, but at a minimum, you comply with the state mandates because they are the ones who are directly giving you authority or prohibitions against operating your business at this time.
You know, the other thing is, every day we're reading articles about COVID-19, and every day we're learning something new about how it gets transmitted, how long it may last on surfaces, how long people may have it. And on a regular basis, we're seeing updates to all of these guidelines. How does a business sort of deal with the fact that, you know, in the beginning of March, COVID was around, but nobody even really knew that there was anything to be done? And now, you know, fast forward to later on in June, there's a lot more that needs to be done. How does a business deal with this sort of moving target?
The simple answer is let the state and let the CDC do their work. You don't need to research the emerging science behind the transmission, spread, and sort of bacterial or microbial properties of COVID-19. The Department of Health in New York is literally monitoring this on a day-to-day basis, as is the CDC. They're coming out with different guidelines. They are changing their position on, you know, what's effective, what's not effective. Obviously, at the outset, you know, there was a recommendation that the CDC and the NIH were saying, don't wear masks. And now, obviously, everyone's saying you must wear a mask. At some point in time, they said 6 feet is antiquated, that's not enough. And now seemingly 6 feet is the standard for everything. But, you know, from a sort of liability perspective, from a litigation perspective, the timing of when information became public, I think really is going to be a function of when it was implemented into state or agency policies. The fact that there was a paper published in the National, you know, Journal of Epidemiology, you know, buried in page 4,000 probably isn't sufficient to put you on notice that you should have done something different. But, you know, if the New York Department of Health or if the CDC changed their guidelines or changed policy to say that we're recommending that you do X, Y, and Z, you should be doing X, Y, and Z. So the simple thing is don't worry about researching this thing on a nightly basis. Just worry about consistently taking a look at what are the executive orders, what are the state mandates and recommendations, and what's the CDC's position on that. That sounds like a lot, but it's really not.
And, you know, negligence and claims of negligence are always sort of guided by the concept of reasonableness. So the concept of reasonableness in this situation requires that you also think about what your business looks like versus the business where these ordinary rules have been published by the state. Are you a much more high volume, high traffic type business where just following the guidelines and not doing anything above and beyond that is enough? Or do you need to take greater steps than what the bare minimum requirements are that have been issued by the state or federal guidelines?
Right, that's a great question. I was at Chipotle this afternoon. When you walk into the store, you can see they put distance markers on the floor that separate customers 6 feet apart. And they've changed the flow of traffic so that you walk in one door, you walk out another door, and everything is blockaded off to discourage people from touching things or from being close to each other. That is beyond what's mandated by New York Department of Health. But understanding what they are, who they are, and what they attract, there's a huge volume of people that are going through there every single day. So the frequency which they clean their operation and their surfaces and the doorknobs and the glass, you know, they have to do it a lot more than a law firm that has a client come in twice a day and sit in a conference room that's not exposed to anybody else. So, you know, who you are, what you do, and, you know, the frequency of foot traffic for guests, for employees, you know, we would like to think that our employees sit at their desks and just crank out, you know, hourly billing from 8:30 in the morning until 5:30 at night. We'd like to think that's true, but, you know, they move around, but not nearly with the frequency that places like a Chuck E. Cheese or, you know, places where almost by design people are mobile.
Right. So sometimes, you know, following the guidelines themselves will not necessarily be enough to insulate you from having breached the appropriate standard of care that you had to your guests.
Yeah. There are resources out there for people who have large businesses or activities that really don't seem to fit within what the Department of Health is mandating, meaning that, Adventureland or, one of these places where there are, larger crowds and the policies that are being set forth seem to be insufficient. There are companies out there that can come in and do an analysis and make recommendations as to protocols that are far beyond mandated by the state of the CDC, and that they have a more in-depth, and they're industrial hygienists, and they have on-site epidemiologists who have a pretty good idea of how things spread and when things live on surfaces and what kind of materials you need to use, retrofitting surfaces and handles and whatever it might be. So don't be afraid if you've got potential liability for an uncovered COVID claim that turns into a death. It might be worth it to spend some money to have somebody come in and take a look at your business to make modifications and recommendations of policy.
Right. So it's more than just going out there and saying, hey, customers, you can trust us because we're really taking good care of things. It could be protecting you from a significant potential liability that may not be covered by your insurance policy, and that cost and the publicity surrounding that, nobody needs it. So that's just some of the basic things to think about with what is going to continue to evolve concerning these claims. And believe me when I tell you, quite a number of these lawsuits have already been filed for personal injuries surrounding alleged negligence by a business operator due to COVID-19 contraction, exposure, et cetera. And so this is real, it's happening, it's going to continue to happen, and hoping that the government will step in with some immunity or some other way of protecting businesses is a dangerous road when you can take steps now to protect yourself, even if you don't have the ability to transfer this risk to an insurance company, which we certainly hope you do. And having said that, I just want to say I appreciate all of you. Thank you for listening today. Matt and I are glad to have you here. And if you like the podcast, make sure to leave a review and subscribe so you don't miss an episode. You can visit the Schwartz, Conroy, and HackPC website at www.schlawpc.com for more information. I am the insurance lawyer. Have a fantastic day.